10:30 tomorrow, being in the office in uniform, I was taking pictures. 3 years, 4 months, 17 days.
But who's counting?
I got it on my phone.
Count down.
I better turn off my phone, I don't want to get in trouble.
Yeah, because we'll take it. That's a nice machine.
You might have a fighter.
Those we don't get back. That's all right.
You might have a fighter. Just kick him in the knee.
That's it. Sweep the legs, Johnny.
So what do you think of those Red Wings? That was such a disappointing game to watch. I said all the games I take my son to.
So I know it's so hard for me not to because I'll watch you out to the very end.
You got it.
I
Kicking yourself, punching
I'm gonna go show this home. That's how offended I was by the game. Like, I can't watch it.
You go show this.
Yeah, it's like yeah, sure.
It was terrible. They couldn't even get a line over. They couldn't get anything.
And then just like I think it was the third goal before the game.
Yeah.
There, he got 4 goals already. He comes down the right side, and from the camera angle, you have the whole entire
Yeah, what does he do?
to the left side of the net, and he just
Goes right through.
I could have scored that. Anybody can see that. You can't do that for these guys.
No.
And then who you got? So you can throw in more.
I think maybe Michigan skates on one of their shoulders.
I would have thought.
We'll go rock and sock them, man. You can't even bend over to put a ski. So, right.
Yeah, but once you got him on,
you won't
so you
stop.
have
You know what I mean?
to sweep the leg.
Yeah, you're gonna have to sweep it because then you're gonna piss me off. You gotta sweep it. Just take the thing and tap it down and then
Slash on the side.
it's gonna piss me off.
You see, there it goes. My gloves are off.
You want your gloves will be off before you know what happened, brother.
See, it's funny that you get a guy like, I'd scrap the hell out of guys. Because I can skate. Yeah, I wouldn't do it like right now.
You take advantage of that.
Absolutely, every chance I would get.
Smart man. Smart man.
Yeah.
Take a skate. That's a smart hockey man.
I'd be lined up next to me.
Remain seated. Court's back in session.
All right. Thank you very much for being patient. Okay, we're here for the preliminary examination of the defendant as to the charges: manslaughter, death by weapon but without malice, and also on count 3, weapons felony firearm. At the preliminary examination, the burden of establishing that a crime was committed and the burden of establishing that defendant committed that crime rests on the prosecution. The prosecutor called, as far as the witnesses are concerned, I'm going to go over a little bit just to summarize a little bit of what the witnesses stated before I come to my decision. The first witness we heard was from Dr. Keisha, the Assistant Medical Wayne County Medical Examiner. Dr. Keisha performed the autopsy of Mrs. Examined, a 4-inch, 184-pound, 19-year-old female. She came to him fully clothed, although wet, with no footwear. In Dr. Keisha's external exam, he determined Ms. McBride to have gunshot wound to the head with blood on her right hand. No other injuries were noted on her exterior. Dr. Keisha performed an internal exam. He found the pellets penetrated Ms. McBride from front to back and right to left with no exit wound. In Ms. McBride's head was found a plastic wood cup and multiple pellets between 10 and 20. Dr. Keisha also notes no soot or stippling found on Ms. McBride. Based upon that, Dr. Keisha opined that the shot was not at close range within his definition of same, but he did state Ms. McBride shot within 3 feet, which he stated was confirmed because pellets were not spread inside Ms. McBride. No other internal exam was performed. Dr. Keisha also testified that Ms. McBride had a BAC of .218 at time of death and she recently smoked marijuana. He further stated death to Ms. McBride occurred immediately. Cause of death, gunshot wound to head, which he classified as a homicide. He further opined that Ms. McBride was shot straight on based upon the angle of the wound. On cross, Dr. Keisha was asked if Ms. McBride suffered from brain injury prior to the gunshot wound. He was unsure because the shotgun wound masked away any indication. He further stated a brain injury from alcohol, accident, and marijuana, blow to the head could cause a change in one's demeanor, i.e. aggressiveness, confused state, incoherent, dazed. And he also stated it could result in one being quiet and reserved. Dr. Keisha determined that Ms. McBride had active alcohol and marijuana in her system, which could result in brain injury or concussion as well. He further stated alcohol and marijuana not the cause of death. Ms. Beasley then testified. She states that she was at her house at Bramall when she heard a loud crash. She then called 911 first. Then she went outside where she saw Ms. McBride holding her head with both of her hands. Then they engaged in conversation. Ms. McBride was looking for her cell and repeated she wanted to go home. After the conversation, Ms. Beasley left Ms. McBride in the back of the car while she went back inside her home to call for an ambulance. Ms. Beasley describes Ms. McBride as injured, confused, and intoxicated. She also states Ms. McBride was not belligerent, feisty, or combative. After she came back from calling the ambulance, Ms. McBride had left. Next we heard from Mr. Peppers. Dearborn Heights dispatcher, he received a call from defendant. Defendant stated to Mr. Peppers that he just shot someone on my front porch, banging on my door with my shotgun, and he listed the address on West Outer Drive. That was the extent of the call. Mr. Peppers tried to call the defendant back to no avail. Next we heard from Sergeant McMahon. He came to the scene and saw Ms. McBride shot in the head, feet toward the door. He, along with Corporal Crott, headed down the defendant as they secured the scene, and he also indicated that the defendant cooperated fully with him. The officer in charge testified there was no evidence Ms. McBride ever entered the home of the defendant. No forced entry at any door, no damage to any locks. No prints found at any door but smudges. The vehicle Ms. McBride was driving was a family member's vehicle. The front door had a peephole. There was no evidence of alcohol, drugs, or the like inside the defendant's home. The doorbell did not work. He was unknown if the screen in or out at the time of the shooting. The screen door was locked when he arrived at the scene, but he didn't know if the same was open or closed at the time of the shooting. Next we had Ms. Pace testifying. Ms. Pace resides on Bramwell. She witnessed Ms. McBride swerving her vehicle, speeding down the street when she struck a parked vehicle. Ms. Pace confirms Ms. Beasley in her description of Ms. McBride of her not being belligerent. She heard no yelling or screaming by any of the neighbors after the accident as well. Sergeant Kolinich then testified, the firearms examiner. He testified that he examined the shotgun in question, that it was in proper working condition, working the way it was designed to work. He states that the gun cannot have gone off without pulling the trigger, and that a certain amount of force was needed to pull that trigger. I believe he indicated 0.5 pounds, thus it could not have gone off accidentally. Pressure of gunshot can knock a screen off, although it is unknown if it did, according to Sergeant Kolinich. He further testified that one can tell if a gun is ready to fire by the red indicator in the dark. I believe he's Dr. Balish, crime scene reconstructionist. Balish confirms specifications of the gun with Sergeant Kolinich, but comes to a different conclusion of that of the medical examiner, Dr. Keisha. Dr. Balish opines that the screen out of the door at the time when the gunshot fired, and that the shotgun was fired at a close range, less than 2 feet, in direct contrast to Dr. Keisha's opinion. Although they disagree as to the position of the shotgun and distance it was fired, they both agree death did occur from the shotgun wound. As we heard the standard at the Plymouth, as we have heard, and we also had testimony today of a couple of I think it was a co-worker of Ms. McBride and Ms. McBride's best friend. And basically, they added to the equation that Ms. McBride was basically not a combative person, and that even I think the young gentleman stated that he did have occasion to drink with her at one time, that she wasn't very combative and belligerent, which on all accounts confirms what everybody else was saying about McGrath. In her examination, it's more likely than not that a crime was committed and the defendant committed that crime. It is a lesser standard than beyond a reasonable doubt standard. Defendant is charged with second-degree murder and manslaughter. Now the elements that we heard a little bit are the death was act of the defendant acted with malice, and the defendant did not have law excuse for causing the death. As for manslaughter, the death was caused by an act of the defendant. The death resulted from the discharge of a firearm. At the time of the discharge, the defendant was intentionally pointing the firearm at the victim, and the defendant did not have lawful justification or excuse for causing the death. The main difference between the two is this element of malice or intent to kill. Now we know there was a death. I don't think anyone's disagreeing with that. Defendant calls 911 dispatch. I just shot someone on my porch, banging at my door, and then he gave the address. The defense has made an issue about the ID. Although the defendant didn't give his name, and there was no testimony to state that this was his voice over the phone, he did give his address, and the police arrived about a minute after being called. Now, at minimum, this does give rise to a question of fact, whether it was the defendant that called, because when they went to the home, he was the only one in the home. So there is enough to infer that it was the defendant that called, and so the ID issue, I'm not is not prevalent here as far as this preliminary examination is concerned. Now, in manslaughter there are two additional elements. There's the element that at the time of the discharge, the defendant was intentionally pointing the firearm at the victim, and the defendant did not have lawful justification or excuse for causing the death. By for both parties. One shot wound. Ms. McBride shot at close range, while Dr. Keisha states otherwise. This is what we commonly call the battle of the experts, which gives rise, at minimum, to a question of fact. Am I going to believe one expert over the other expert? Well, at this point, at this stage of the preliminary examination, that is a question of fact. Now, we know from the testimony from all accounts that Ms. McBride was not combative that evening or day, if you will. We know she was involved in an accident. She may have hit her on the windshield. She was holding her head with her hands on her temples like this, as was demonstrated, I believe, by one of the witnesses. What we don't know is where she was from approximately 1:30 a.m. to the time of her death, about 4:42 a.m. There was about a 3-hour difference where she was from that time when she left after the accident to the time of her death. Now, the defense argues intent in the Self-Defense Act of 2006. Well, the word reasonable person was used for this Self-Defense Act. Well, let's examine that. 30 in the AM on side door, back door, front door, all doors. Defendant had the use of a peephole. What could a reasonable person do in defendant's case? What did he do in his case? He brought a shotgun to the door. What is he going to do with the shotgun? Well, what is he going to do with the shotgun? He's either going to shoot a person, scare a person, or he's going to protect himself. Now, what are other things that he could have done? Well, he could have not answered the door. He could have called for help. He could have ran to another area of the house. I know this is his house, and I know someone was knocking on his door. There is evidence to infer that the defendant could have done just that, other options, as opposed to shooting first. Yeah, he had chose to shoot rather than not answer the door or use some of the other options. The shotgun itself was fully operational, as both experts tested a certain amount of pounds of pressure was needed to pull the trigger, which does not, at a minimum give rise to a question of fact as whether this was an accidental discharge of a gun, or whether there was some thought put into pulling the trigger. Now, great bodily harm. If we weren't, then people would run stop signs, red lights, etc. We must make a split-second decision on a daily basis. Beasley, I believe, case, and when she, before she went out after Miss McBride hit her husband's car, she stated she wanted to assess the situation before she went out. So what did she do? She called 911 first before she went out. In other words, she thought first, then she acted. Now, yes, this court recognizes we can't automatically penalize one for making a bad decision when pressed to react. The bad decision thought was to bring a gun, not call for help, or not answer the door. As for the evidence that has been taken in this preliminary examination, it suggests to this court defendant made a bad choice when there were other reasonable opportunities that were available to the defendant at the time. So, based upon the testimony in open court, based upon my reasoning here, I do believe that the prosecutor has met their burden by probable cause that a crime is committed and probable cause that the defendant committed the crime of second-degree murder and manslaughter. Now, although this is a different burden here in this preliminary examination, the results could be different at trial, but from what I'm hearing in this preliminary examination, I do believe that the prosecution has met their burden, and I will bind the defendant over as charged. Having said that, do you have the notice of the arraignment date?
No, Your Honor. Thank you. Yes, we did. Can I
Okay.
know what it is?
And that date is?
January 15th, thank you, 2014.
All right, January 15th. Bond will continue. And thank you very much.
Thank you, Your Honor. Thank you, Your Honor.